All right, we are live on this Tuesday night, um, June 18th. And guess what? It's June 18th, and you all are going to see me do something that I never do. My head is all shiny, so I'm just going to clean it off a little bit. All right, so it's June 18th, Tuesday night, and I'm a little bit in trouble because um, I did this myself because um, I was supposed to be on with our guest earlier, and somehow I got the time screwed up. But the good thing about podcasting is that you can make it up, and when you own the space, you can do whatever you would like to do. So I'm not on transistor radio or anymore. Was that what they call it? Uh, I forget. Terrestrial radio, whatever they call it. But I'm not on that anymore, and so I can speak freely about the issues, about the policies, about those things that impact our communities. And I can speak freely about those things. So I want you to come on in, join me for this special hour that I'm going to be doing. Judge Leonard Murray, who is the Cook County Circuit Court judge, supervising judge, is going to be joining me momentarily. And of course, we're going to be doing our makeup show of the Legal Hour on the People Show's Legal Hour that we normally do with you every Saturday from 1 o'clock until 2 p.m. So join us for this hour. We're going to be talking about mostly all things legal, and we'll be taking your legal questions. Judge Murray, if you have some legal questions, you can put your questions in the chat, right? Put them in the chat and send your legal question. I'll read it off to Judge Murray, and he will answer your question. Now, a full disclaimer, we cannot give legal advice. The judge cannot give legal advice. I can give you my opinion. The judge can't give you legal advice, but he can certainly tell you what the process is um, and how that is viewed in the courts. And then hopefully that will be some help for you. If you don't have an attorney, you can get an attorney who can better help you to understand what that is, and then you can go out and hire an attorney. But or you can determine or find out based on the question that you present whether or not you have a cause or whether or not you have a position to take legal action based on whatever it is. But again, he cannot give you personal legal advice about your individual situation. He can just answer legal questions as it relates to the law. And so we're going to get started. Judge Murray is here with me, joining us here in the studio on the program. Judge Leonard Murray, how you doing, Judge Murray?
Good, Mark. How you doing?
I'm doing great. Thank you for your patience. I certainly apologize for this two-time screw up in terms of getting the schedule all mixed up. I was out getting some final stuff ready for tomorrow. Tomorrow is Juneteenth, and I guess it's the second federal holiday of Juneteenth, right? This is our second year in a row. I believe it's the second year, isn't it?
Yep. I'm sorry. Say that again.
This is the second annual federal holiday for Juneteenth. Yeah, Juneteenth. So tomorrow's Juneteenth. We're going to be at the DuSable Museum.
Yes.
Yeah. Okay. All right. So that means the courts. Does that mean the courts and everything is shut down tomorrow, right?
Yeah, I think the state had acknowledged that before the feds did.
Okay. Meaning the state of Illinois. I think we lost Judge Murray. Hopefully, we get him back. We've lost his signal. Um, we lost his signal, so we'll get him back in just a minute. Hopefully, we can recapture that. Okay, Judge Murray, I think we can go on, but I think the audio is still up, right? Can you hear me? Judge Murray? Let's see what we have going on here. Okay, I think, let's see. We're going to take Judge Murray off, and then we're going to bring him back into the studio. Wow. I think that this is what happens. The downside of what happens in digital is that we sometimes lose the connection. So while Judge Murray is reconnecting with us, again, tomorrow is the second annual Juneteenth holiday that is federally recognized, and that we will actually be celebrating Juneteenth. And in our celebration, we should have a sober approach to our celebration, certainly celebrating the fact that it is being recognized of the protection from states' rights by the federal government intervening and protecting one federally from states' rights. That's what happened in Texas when the Emancipation Proclamation had been signed in 1862, September 21st, 1862, went into effect January 1st, 1863. Well, for 2 years, the people in Texas, I believe, did not know that they were freed federally from slavery, but the state did not advise the people who had been enslaved in Texas that they were free. And so the federal government came in and the union came in to let those people know that they were free in Texas. So this happened on June 19th of 1865, which is why we celebrate Juneteenth on the 19th. So tomorrow is the actual day that we commemorate the freedom of those who had been enslaved illegally for, I guess you can say, 2 years. So it's 246 years that people were enslaved. And so the people out in Texas were protected by the union of the federal government. All right, Judge Murray is back with us. So as I was saying, Judge Murray, we're going to be 10 by 10 to win is going to be at the DuSable Museum, which they're having a whole day of events starting at 10 o'clock tomorrow, from 10 o'clock until 8. They have all kinds of events going on. We'll have a booth there and giving people information about the galvanizing and building of an independent black voting bloc in Chicago and Cook County in the state of Illinois. I will also be talking about the importance of a collective, organized voting bloc and what that really means in terms of having real political muscle, strength, and power, and then also talk about some of the statistics of things that exist and what's happening coming out of the Biden administration and the investments that's actually being made here in Illinois and around the country, and the importance of why it is that's important that when we vote, that we make an informed vote rather than a misinformed emotional vote. So we're going to be doing that tomorrow at the DuSable Museum.
Okay, and yesterday on Daily Plaza, which is right next to the courthouse, there was a Juneteenth celebration that I understood the mayor's office developed. and it went on for a good part of the morning and then extended into the noon hour as well.
Mhm.
And there was a decent crowd there. Even though it was a very warm day, there was a decent crowd there, and they were uh, distributing some trinkets. I got a red, black, and green flag that I'm now uh, displaying in my chambers. But there were a
Okay.
number of other things that were being circulated for those who attended and had an interest in receiving some token of the event. And the mayor
Yeah.
also, as I understand it, uh, was there at the beginning of the event, and I think and somewhere around 30 or so in the morning. So it went on for quite a lengthy time.
Mhm. Well, I think that was it yesterday or was it the day before that the mayor announced he announced an executive order on moving a closer or furthering, and I don't know what that executive order was, but it has something to do with reparations. I don't know, was it yesterday that he announced that, or was it the day before?
I'm not sure when it was,
Okay.
and I haven't had a chance to review the order.
Mhm.
Um, but I think you're right. It may have been Sunday that
Okay.
it was announced.
Yeah. Yeah. So, um, yeah. So, there's going to be a lot of things going on. Obviously, this past weekend, there were several Juneteenth events going on. The actual date is tomorrow. And so I imagine a lot of people are off from work. I'm not sure how the private firms and private businesses are handling that. And, in terms of giving their staff time off to recognize the date, even though it's a federal holiday. It's a governmental federal holiday, obviously, so that means that all federal employees are off. Now all of the states and the cities governments are closed in Chicago, right?
Yes, courts are closed. County government, city government. Police and fire, of course, are always
Right,
uh, on duty.
right.
But standard city services, except in the case of emergency, aren't available.
Yeah, yeah. Unfortunately, we had a weekend of, I think, 77 shootings in the city of Chicago. Um, uh, which is, always kind of a travesty in the wake of the Supreme Court striking down the Trump ban on bunk stock. Is it bunk or bump stock?
Bump,
Buck stop
bump
ban.
stop.
Bump stop. Okay, bump stop ban, which now the Supreme Court, and it was put into place by the Trump administration. The Supreme Court struck it down, and the Supreme Court struck it down, saying that it was that the only way that this could be imposed is that it would have to come through Congress. Well, it was bipartisan then, and now uh, they brought it, uh, proposed it, and you now have Republicans that are objecting to it.
Well, I have not read the opinion, but I think it was authored by Justice Thomas,
Yes,
who I think reasoned that uh, the definition of an automatic weapon was not met by the regulation that was imposed. So therefore, because it did not meet the definition of an automatic weapon, which I guess there is congressional um, uh, legislation about, the bump stop could not be covered by that legislation.
yeah. In the wake of the deadliest mass shooting in the history of the country, where 58 people were killed, I believe, in less than 2 minutes in Las Vegas, and that person used a bump stop to modify the weapon that he had to do and that carnage. And um, I cannot wrap my head around what is going on in the conscience of the people who sit on the highest court in the land. I have my opinion as to why I think Justice Thomas does what he does, but it is who he is. But I think that, well, you know, they're certainly influenced by a lot of money. They're certainly influenced by a lot of money. And I can't, for the life of me, understand how this cannot be stopped, even by Congress. Even by Congress. Because if the highest court in the land, the justices on the highest court in the land, what does that say about other judges and justices on the appellate court, on our circuit level, and our state courts? What does that say about them? Does this open up a path for this to happen with anybody who is a judge or justice in the judiciary?
I'm not sure I understand the question, but
Well, the question is that because Judge Alito and Justice Thomas are the two, now I'm sure there's others, are receiving these massive gifts from people like Harlan Crow, and and then in some cases they haven't even reported these massive gifts. Why would a justice be receiving millions of dollars in gifts from anybody and accepting that, or even allowed to do that sort of thing?
well, that's a question that has certainly been being debated now on a national level, um, and that is because we have these three independent branches of government, the judiciary, uh, meaning the Supreme Court, although it does impose certain um, ethical uh, rules relative to the lower courts, uh, circuit courts, federal circuit court, and the federal district courts. Uh, those same rules and regulations don't apply to the Supreme Court. And because we have these three independent branches of government, each of which within its domain is self-regulating, there's this debate over whether or not there's really anything that Congress can do in order to assert some sense of ethical conduct and code on the Supreme Court. Now, one of the ways, of course, that Congress controls government is by its funding mechanism. So the Supreme Court, despite its independence, cannot fund itself. So if the Congress decided to do something relative to funding, um, maybe that would send a message uh, that we expect some regulation of your own conduct. But I'm not sure. Um, uh, but certainly the court needs. I don't know what the Supreme Court's budget is, but certainly it needs funding to operate. Um, it has they have staffs, they have clerical folks, they have a library. A number of years ago, I was fortunate enough to uh, go on a trip to the Illinois State Bar, a swearing-in ceremony that they do annually. Uh, and I witnessed. I was not sworn in myself, but I did witness the swearing in of a number of people who were part of that group. So I have actually been in the Supreme Court's library, uh, and it's a fascinating place. And a friend of mine, a lawyer from downstate, Mark Hasikis, uh, is a classmate of the woman at the time who was actually the Supreme Court librarian. So I get a chance to um, see certain parts of the library which are typically not available to the average visitor. But it's a fascinating place of history. Also, the fact the Supreme Court building was built by slaves.
Yeah.
So that's something that folks should realize and appreciate.
Yeah. I got a chance back, I believe it was 2015, to go to the original Supreme Court here in Illinois, the state Supreme Court, when the Supreme Court, their current um, offices were under renovation. So they were holding, um, um, they were listening to cases at the old Supreme Court building. And our case was argued in that old building back in 2015 out in, is that
Is it Ottawa?
Ottawa? Ottawa, yes,
Yeah,
out in Ottawa. Yes, Ottawa,
yeah,
Illinois. Yeah.
yeah. That is the uh, currently that building is now proceedings are conducted there by the Third Appellate District. Um,
Okay.
and in fact, I argued was part of an appellate process on a case for the dealing with prisoners' rights
Mhm.
that was argued before that court at that time. Uh, and that goes back a number of years for me. That goes back probably to the 90s.
Yeah.
But it's this historic location. I think there was a debate there. I think the Lincoln Douglas
Yes.
debates were,
The
were held
Lincoln,
there.
yes, the Lincoln Douglas debate was held right there. Yes.
Right. But yeah,
Um,
Illinois does have some very historic edifices around the state that should be visited by everyone so they get a sense for the history of the state.
yes.
Uh,
Mhm.
um, but yeah, I have been in that building. I'm pretty sure that's the third appellate district. And
Yes.
your audience may be aware that Illinois has uh, five appellate districts, and that determines where our Supreme Court justices come from. So
Mhm.
the first district is comprises Cook County. So that's the first appellate district, and there are three justices from Cook of the seven. The second district is north of Cook and out towards the western part of the state. Then the third district is the area around Ottawa. The fourth district is around south of there, the Springfield area. Then the fifth district is Mount Vernon. It's the southern part of the state.
Mhm.
And the other four districts, there's one justice who hails from those districts that comprises the seven justices. And it's also an interesting fact now that of the seven-member court we have now, there are two males now. The other five are women. There are two women from Cook, and there's one woman from the second district. Um, think of her name in a moment. In the third district, there's a woman, O'Brien. The fourth district is a black woman. Let me think of her name in a moment. And then the fifth district, there is a white male member currently. Um,
Mhm.
but um, anyway, so that's the composition of the Supreme Court in Illinois.
Very interesting education that most people don't know about, but I think it's a good thing that people should be educated about how our judiciary works and how it is actually structured. Um, and I have the privilege of knowing some people who are intimately involved in the judiciary. But it certainly is interesting when you look at the juxtaposition as to how the highest court is behaving and the restrictions on people in and how they behave in other areas of the judiciary, even in government. I remember when I was served as a commissioner on a um, special service area, an SSA, when Sandy Jackson was an alderman in the 7th Ward, and I served as a commissioner on the SSA that she um, was successful at getting started in the ward. And as a non-paid commissioner of an SSA, I was held to the same standards, the same ethical standards as any other elected official. I could not receive a gift for more than $50 from anyone, and I was still held to the same requirements as any other elected official, which is, fine by me, but it's astonishing to me. It really is astonishing to me how the highest court, we are seeing how that court is being, um, you know, um, a lack of oversight and the kinds of things that they um, are doing. I don't know if this kind of behavior existed before these Supreme Court justices and we just didn't know about it, but it certainly is disturbing.
Well, part of it, I think what has been revealed as a result of this situation that we're now facing is there were certain things that were not disclosed and then subsequently amended when I suppose the press uh, discovered it and raised the issue as to why it had not been included in the annual disclosure forms required by the court.
Mm-hmm.
And I want to say that as to Justice Thomas, if my memory is correct,
Yes.
and it relates to the connection you mentioned of I think the name is Brian Crow, um,
Harlan Crow.
Harlan Crow.
Mm-hmm.
Um, but apparently there was some I think trip abroad which was not included in the annual disclosure information that the U.S. Supreme Court justices complete. Um, and there was an issue raised about how could such an oversight occur.
Mm-hmm.
Uh, and for example, in Illinois, we're required to complete uh, 2 disclosure forms annually. Um, in fact, they were just due at the end of April. The first is a form that we filed with the state Supreme Court. Uh, and in that form, you're required to reveal your financial uh, holdings. And also, you mentioned acceptance of gifts and so forth. That's required as well, along with whether or not you have any connection with a practicing lawyer, such that it could uh, compromise your independence, your integrity, and that must be disclosed, even though that person is not a family member. And this disclosure form covers yourself, your spouse, and any minor children. Adult children are not covered by this disclosure. And that's a document that required to be filed with the state Supreme Court. And then there's a second form that we filed with the Secretary of State where you required likewise to reveal certain um, financial um, uh, connections that you have. It's a 2-page form. It's pretty simple, uh, and you're required to disclose certain things there. Um, and this is annual, and those forms are available for inspection by the public. And sometimes in litigation, if you were a judge who was doing a case, um, the lawyers could ask for a copy of that form to see if there's some potential conflict that you might have that they're unaware of. If you own stock in a company and that company has a lawsuit that happens to be before you, the question would be whether or not that ownership interest might somehow affect how you would rule in the case. Um, so that disclosure then gives the public the opportunity to ferret out and raise the question in certain situations as to whether or not there's a potential conflict that you might have.
Yeah, yeah. Clarence Thomas received, I think, it was 103 gifts over a 20-year period worth more than $2.5 million from one individual. Even purchased his mom's house, which his mom still resided in for free. So, um, um, you
Not
know,
only the house, but land surrounding the house.
correct,
Yes.
correct. So, um, why somebody would be doing that for somebody in the judiciary, uh, I don't think that they were doing it just because they thought that this person was such a great person of honor doing work um, in the judiciary. It just is very interesting, very interesting. Um, I know that we talked about some things, and I still didn't get that question out. There was something that we were talking about. We were talking about related to the last time that we uh, talked about um, uh, dog ownerships and car impounds,
Hmm.
and we were talking about an owner of a car who was not involved in an incident, or somebody was using an owner's car, was involved in some sort of criminal activity in that owner's car, and what the liability or responsibility of the owner um, of that vehicle was in terms of getting their car out of the impound. Um,
Well, I did recall that was a question that we may not have fully explored the last time um, we were together. So I do have a list, at least, of many of the situations that can result in an impound, and also what the possible fines are. And let me just start by saying that um, if there's a police encounter and there's some activity that the police believe is a criminal act, just quick example, driving on the influence, uh, then they can seize your automobile, or they can seize the automobile that you are operating, whether it's yours or not, impound that vehicle, and then you could be subject to a fine, and I believe the fine is $2,000 for driving while under the influence. And again, it does not matter that you don't own the vehicle. The fine is imposed on the owner of the vehicle under the principles of strict liability. So if you loan your car out, you need to be very careful who you give the keys to, because you could be looking at a hefty bill if they engage in some activity that is deemed to be criminal at the time of the stop. It's not a criminal adjudication. It's just a suspicion of that there is a criminal activity involved. So let's just pursue that situation of someone who is stopped on the roadside. Um, the officers go through um, a number of tests um, to determine whether or not they believe you're under the influence. And there's some things out there you can actually Google what those tests are. They do balancing tests, heel toe. They look at your eye movement and, of course, odor on your breath uh, to come to a conclusion as to whether or not you're operating under influence. What's interesting is that you need not have operated a vehicle in a fashion that would suggest that you are impaired. It's merely whether or not, as a result of the stop, um, this impairment or impairment meaning that you are under the influence is determined. So if that's their conclusion, and it does not also require that you blow into the device that is used to detect alcohol in your breath. You're not required necessarily to do that as well. In fact, many lawyers advise clients not to blow in those situations. It does have an immediate impact on your license, of course, and I'll speak about that in a moment. Uh, but an arrest will likely occur, and the car will be impounded, and there is a notice process that you're given, or I should say, the person in possession of the vehicle is given, and also a notice is sent to the registered owner, who may not be present at the time of the stop and then the arrest, of the right to contest the impound. Now, it's important, and that's a 15-day period within which you must request a hearing. If you don't do that, you have waived your right to have a hearing, and therefore that fine of $2,000 essentially is fixed in cement. You can't do anything about it because you didn't request a hearing or keeping the issue open. Now, uh,
The
the other
owner
thing,
of the vehicle.
the owner of the vehicle, okay, not the operator at the time, but the person who is the registered owner.
Mhm.
And in that regard, it's important that folks keep current their registration information. So if you have moved and your vehicle was registered at the address that you moved away from, then that notice may not come to you because it's going to go to the registration address uh, that the vehicle was last given to the Secretary of State. So it's important that you keep current that registration information because notices are not going to come to the address that you may be at presently, uh, where you've moved to. It's going to go to the address that you've moved from. So in that context, the notice is sent to the registration address, and if that's not where you live at the moment, uh, the mail being what it is, it may not be forwarded to you, and you may blow the opportunity to contest whether or not the vehicle should have been impounded based on the suspicion of DUI. Now, so then in that scenario, what you get is the person in possession of the vehicle who's operating it gets arrested for the DUI. So that's on the criminal track. But simultaneous with that is the impound of the vehicle, which is on a civil track. So it may well be that the DUI, which is a alleged criminal violation, uh, results in a not guilty. That does not automatically mean that the civil track, the impound, will automatically be realize the same result as a criminal track does. And the other thing is that typically the criminal track is going to take longer. Criminal cases they take the
Mhm.
time that they do. The civil track, they tend to try to move that, and this is the administrative hearing track. They tend to try to move that process quicker. So um, it's incumbent upon someone in that situation to make sure that they try to uh, continue that administrative hearing until they can determine what happens in the criminal process. And again, uh, even if you are successful, uh, or the person who is arrested and charged with the driving under the influence is successful, and either for example, realizes they're not guilty after trial,
Mhm.
or uh, there is a motion to quash arrest, suppress evidence that is filed that says that it was a bad stop. So therefore, everything that occurred after the stop is not evidence that can be used. Uh, you have to keep both balls in the air, if you will, at the same time. If you let the ball fall relative to the administrative track, then even if you ultimately determined to be not guilty, or there's a constitutional violation uh, by virtue of the stop, then you will likely have forfeited any chance to undo the impound, because you didn't keep that process going along in order to take advantage of the successful outcome in the criminal trial. And I see that from time to time where, for whatever reason, uh, uh, those two tracks are not kept going, because it's not always the case that it's the same person involved. The owner of the vehicle is not the person operating it. So when you get essentially two defendants in different uh, uh, settings, judicial settings, um, if if they don't coordinate their efforts, then it could turn out unfavorably to one of them relative to the impound.
What this to me reminds me of red light cameras, or speed cameras, because a car does not itself run a red light, or a car itself does not exceed the speed limit to a violation. A person operating that vehicle does. So if the person operating the vehicle is responsible for that offense, in the same way that a person that uses someone else's vehicle, and that person goes out and commits a wrong, why then is the owner of that, why does that person have any responsibility? Um, and why couldn't they treat it like a leased car, that they can prove that they allowed for this person to operate their vehicle? Therefore, any fines relative or related to that vehicle should be passed on to that person.
Well, because the ordinance is a strict liability ordinance, so the fine is not imposed on the person operating the vehicle at the time.
So the fact that you're saying a strict liability means that it is,
So
um,
it's on the owner,
it's on the property.
right? No matter whether the owner is operating the vehicle at the time or not, it's on the owner.
Okay,
So it's derivative, if you will.
right.
So just in your example, your son or daughter is driving your car. Um, they're above the limit allegedly. It triggers that camera that says that red light, or speeding camera that says you're exceeding whatever the limit is in that location. That ticket's going to come to the owner of the vehicle.
Right.
It's not a police stop. It's a police stop for speeding, and then of course, the ticket's going to be given to the person operating the vehicle. Um, Likewise, a stop sign or red light ticket issued by an officer. But for the most part, you don't see very many traffic enforcement situations by police officers anymore. Um,
Yeah.
they, they rely those electronic devices that are present, on our city streets to enforce those ordinances. Whether that's good policy or not, that seems to be the case.
Right. Seems to be what they've decided, that um, rather than having real safety oversight imposed, that this is a better way to do it by just imposing fines. And if we impose enough fines, then that will be the deterrent for um, bad driving behavior. Maybe that's the theory.
Yeah,
Or
I,
like
I don't.
they like to tell us that's the theory.
Yeah, I don't.
Yeah,
I won't profess to know
yeah,
what the rationale is, or speak to whether or not I believe it's a good one or a bad one.
right, right. Okay, so well, that's very interesting. Strict liability. I guess that's the same way on photo enforcement. Um, let me switch. Let me ask this. I'm going to jump around a little bit to this, but let me ask you this because this is something that came up on a foreclosure sale, right? So now you there was a foreclosure sale that um, the owner of the property is deceased. The property itself is uninhabitable and boarded, right? It's boarded up, uninhabitable. And there is someone who is using the garage of that property, but they're not living on the property. Is that property or does that constitute occupancy and that person has to be evicted by the person who has purchased the property at a foreclosure?
That's an interesting question. I would say that, well, calling back to my time in landlord-tenant court, or more properly known as forcible entry and detainer, uh, the principle of when a notice is required and a judicial eviction process commenced is when the entry is peaceful. In my mind, peaceful means that someone who had authority to allow access did so. Uh, Based on what you've suggested here, it sounds like this is a trespass, which would not be a peaceful entry. So therefore, essentially, you could call the police, whoever is now the owner of the property. Um, if it was foreclosed property, then this person was the successful bidder at the sheriff's sale. Um, they've been issued a deed that's been recorded, so their title ownership is in the chain of title. Um, I would think you probably could call the police and suggest that this is a trespass, and this person is not entitled to be to occupy the space. Now, the other thing, but and there's some situations I've heard of where the police just they don't want to get involved because they think it's a civil matter, so
Right.
therefore, go to eviction court. Uh, but in that situation, I think you would have a right to immediately go to eviction court and seek a possession order because there's no right to possession that that person um, possesses because they were not given authority to use that space.
Would they, so would you go back to the same court that approved the sale, or would you have to go to a, um, an eviction court?
Well, normally the judgment of foreclosure and sale includes a right of possession
Mhm.
um, to whoever ultimately is the successful bidder at the sheriff's sale. So I would think then that order uh, would be one that could be enforced by the sheriff, um, uh, given that it stems from uh, a purchase of the property at a judicial sale.
So you
So,
would take the possession order that was issued and just go to the sheriff's office and file that with the sheriff, and then the sheriff would go and do their normal posting. If they go there and do a posting and they see that the place is boarded,
yeah,
that would constitute that there is no occupancy there.
right. And once they do that, then of course, anyone on the premises would be a trespasser.
Right. Okay, that was a question that came up because someone purchased a property, and there was something. Also, it was suggested that that they could do what is called a position or petition to intervene.
Intervene in what?
Um, in order for them to get immediate possession. So they bought the property. They bought the property, or they're the successful bidder. They were the successful bidder. So they don't technically own the property. They have a certificate of sale. And now it has to go to the courts, and the judge has to approve that sale. And once the judge approves that sale, then a deed is issued to that person.
Correct.
So during that process, it was suggested that they could go and do what's called a petition to intervene because they don't have a material right of the property as such.
I don't see the utility in doing that.
Okay. I didn't understand it either when they were talking about it.
I think you should, once the sale is approved, the deed is issued, then you're the title holder.
Mhm.
So that person obviously is a trespasser. Given the fact that the property's boarded up, it's unoccupied, and the person in the chain of title is deceased. We don't know whether or not there are any heirs of record relative to being given notice. But in any event, I mean that's the burden on the mortgagee's law firm to make sure that they invoke court jurisdiction to have a valid order entered, one that can't be attacked in terms of a failure to give adequate notice to parties in interest.
Right.
So assuming that's perfected, then once the deed issues, then the new owner should be able to secure the property because that garage is not a residence.
Mhm.
And I think what you're saying is that at least the facts that is given to you suggested that uh, whoever is using the garage is not using it as a residence. They're doing some sort of work there, I suppose.
Mhm.
So therefore, it's not a residence.
Or storage or whatever.
Yeah. So I would think their rights would be very thin if they exist at all.
Mhm. All right. Well, that's. I will certainly. I'm going to follow that because I want to see what actually uh, happens when they actually go to record their deed and then to go to take possession
Mm-hmm.
of the property at that time. And then obviously, it's like you said, I believe that it's probably more likened to what you said, is that even if they call the police is going to come out and they're going to say, this is a civil matter, you need to go to court and have the court to resolve it. We don't get involved in these kinds of situations. Kind of, similar to which I guess where there was a case where a person is in foreclosure It has not been fully adjudicated because the sale um, hadn't taken place, or the sale had taken place, it just hadn't been confirmed, and that the mortgagee sent a property preservation to go and gave them orders to go change the locks and all that sort of stuff. And they technically are not in possession of the property. Kind of a
Well,
similar situation.
yeah, I would think that the mortgagee in that situation has some exposure because uh, they have trampled on the rights of the owner. The owner's rights have not been taken away yet.
Right.
I think they probably have some exposure there.
Yeah. Um,
So
yeah, that's,
they would be the trespasser.
and I just wonder how many times that sort of thing may be happening. Um, that it's because there were two, this happened three times on the same property, three different times on the same property. Um, that and the only the third time that it happened that the police um, said to the property preservations that if you guys come back here and you don't have a court order and you enter this property, we will take you into custody. It took three times for the police to effectively say, hey, enough is enough. This is not the appropriate thing. They wouldn't do it the first time. And the first time when they said it, I said, what, wait a minute. Because the first police officer said, well, if he doesn't know and they're operating on behalf of the bank, we don't know that. So I said to him, wow, so I could go and break into somebody's house and say, if the police showed up, that I was there acting on behalf of the bank and they would just let me go.
So you realize that that statement didn't make much sense.
Right. 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 So, um, but I think that in some cases that this is their easy way of saying, you know what, we really don't want to be bothered with this, right? We don't really want to have anything to do with this. When in fact, it's almost that the victim at that time doesn't really have any recourse. I mean, there's some strange things happening to where um, one person, because your last line of defense is the court, right? If you believe that your um, rights are being violated, then the court is the arbitrator, is where you go to get that settled. And then when you do all that you're supposed to do, and the um, the I guess the enforcing body decides, well, we're not going to do that. Where where do you go? Where do you turn to?
Well, in that case, you probably need to go up the chain in terms of the police command. Um, but I don't know that there is, unlike the situation where only the sheriff, uh, uh, at least in our system, can enforce a court order. Um, the police uh, don't have a similar obligation to serve and protect
Mm-hmm.
uh, as what the sheriff has obligation to in terms of enforcing um, the orders of the court. Um, it probably is a bad PR situation for them um, to refuse to act in certain situations. But I don't know that legally an action against them would lie for failure to do certain things.
Yeah.
unless you could demonstrate that you were harmed by, their inaction.
Mhm.
Um, but but in the normal circumstance, I'm not sure that they can be forced to do that. It's I guess it's a diplomatic situation where you'd have to see if you could go to the district commander and explain the situation and get them to order uh, the beat officers to take a certain action. But
Mhm.
uh, I don't think you could run the court and get an order that directed them to do anything.
Interesting that you brought up the sheriff, and we're running up against the clock. When you said that the sheriff has an obligation to enforce a court order, so the sheriff doesn't supersede the court, right?
Correct.
And so the court listens to evidence, um, and makes a determination. And once that court has made that determination, it has adjudicated and made a decision and given an order for the sheriffs to execute that order. And when the sheriffs look at that order and decides that they are not going to enforce that order, can the sheriff be held in contempt of court by not enforcing or choosing not to enforce that order?
But I think you would first bring a motion asking a court to direct the sheriff to execute an order. And that would have to be, the propriety of that would have to be adjudicated. Um, um, and that's why how orders are drafted is important,
Mhm.
because if there's any vagary relative to the order, then it could be a situation where the court could conclude that the order is not specific enough for the sheriff to act on it. In fact, I had a case where there was an action brought against a restaurant, uh, and it was in enforcement entertainer court, but they were not going after the entire premises. It was only a part of it. But because of the way the order was drafted, uh, there was certain uh, vagueness involved, and I deemed the order I didn't wasn't the order that I entered. Kind
Mhm.
of inherited the situation. I deemed that the order was not specific enough uh, to require that the sheriff be forced to execute it, and that the the party who was benefiting from the order would need to have it uh, modified with exactness in order to have the sheriff effectuate what the intent was. But the way the order was written, it was not clear what the intent was.
That's yeah, that's that I can see that there's some vagueness there that the sheriff is not clear on that order. But what about a situation where the sheriffs actually go out to do an eviction, and then the sheriffs decide for whatever reason they're not going to execute that eviction? There's no humanitarian concerns in place. There's no human beings living there. There's no seniors there with any type of um, social or medical needs. But the sheriffs decide we're not going to do it because there's a certain kind of institution. And then they go back uh, and they don't offer any legitimate, even legal reason why they're not going to institute or they're going to execute the order, other than they don't want to execute the order because it's a certain kind of institution.
I don't think they get to pick and choose which orders they enforce against certain entities. I think the only way that the party who is entitled to seek possession can acquire is by the sheriff's enforcement. You have no alternative. There is no alternative uh, um, agency, if you will, that you could turn to have that order enforced. It could not be enforced by for example, the police department, because the province of court order enforcement is left to the sheriff.
And in this example, the sheriff is basically saying to the property order that the court has already said, I'm giving you relief by ordering that they return your property to you. The only way that you could have your property returned to you is by the sheriff, but the sheriff is saying, in effect, we're not going to give you your property back.
Well, then you would need to go to court on a motion to have the sheriff, to compel the sheriff to execute that order. And court would enter an order doing that, and then if they continue to fail to do it, then uh, you would file a petition for rule of show cause.
Yeah. Very interesting. It's a very interesting position to see that this is happening. I do know that during COVID, I do remember during COVID, before the moratorium was put in place, that the sheriff basically said that they were not going to be doing certain evictions.
Well, there was a governor's order that forbade execution of possession orders during that period. I think it was roughly, I want to say it was roughly 3.5 months.
Mm-hmm.
So the sheriff couldn't do it anyway,
Mm-hmm.
because the governor's order precluded the execution of possession orders during that period.
Right. Right. I recall the acquisition of a property during that period, and it took, I don't know, 18 months because of that. It was in place. It couldn't. It still went through the process, right, of being adjudicated, but it could not be enforced because there was an eviction moratorium in place there. All right. Well, listen, these have been some really interesting circumstances and theories behind them. I think we have, I certainly hope that people listening to this and watching this, that you got something out of this. If you have been faced with any of those situations, the judge is here with us every week. I don't know, Judge, this time frame might not be such a bad time frame. People may want
to. Yeah, that'd be fine with me.
Okay.
Free up my Saturday.
Okay. All right. So maybe we can look to Tuesday nights at 9:00 that you'll hear from Judge Murray and myself. All right. So we're going to try it again next week, the same time.
All right.
So those of you, if you have any legal questions, you can always write me and you can go to my Facebook page, or certainly go to email me at markjwus@gmail.com, and send us your legal questions, and the judge will address them, just as we were talking about situations here tonight. So we want to thank you all for tuning in to this Tuesday night edition of the People's Show's Legal Hour with the Cook County Circuit Court Judge Leonard Murray. We'll be back again next week with another edition of the People's Show's Legal Hour. Same time, same place. Have your legal questions ready for us. All right? Take care.
All right. Thanks, Mark.